Everyone, today we're going to be doing a webinar about the President Biden's Keeping Families Together Parole in Place program. We are recording live on TikTok and some other locations, as well as this will be on our YouTube later on today and some other locations on our social media. My name is Ruby Powers with Powers Law Group, and I want to go ahead and get started. So we're going to do a little bit of an overview. So maybe you already know that, and then we're going to get to what's going on with the temporary restraining order and future what we think about the lawsuit and things like that. So the initiative was started, announced in middle of June. And they basically were saying it was a way to promote family unity within the United States and provide a pathway for non-citizen spouses and stepchildren and U.S. citizens to remain in the country. Gives me a lot of vibes to the provisional waiver program that came out. It was announced in like March 2013, because before people had to leave the country, wait to be told that they needed a waiver, and then submit the waiver and wait outside the country. And so provisional waiver was a great, wonderful program when it came out. Unfortunately, it went from taking only maybe 3 to 6 months for a waiver to taking 4.5 years. 4.5 years. I mean, basically, your kid could be ready to go to kindergarten by the time your waiver gets approved. Oh my goodness. So the point of this was to have a effort by the Biden-Harris administration to enhance stability and economic prosperity. If you read, which I did, the rule, it's really well written, honestly, and the reasons are wonderful. You know, people can have better jobs and social. They can provide better opportunities for their families. It's like people can get out of the, you know, they can get out and be put in the system, and people for security reasons they'll know about who's here in the country. It's actually a lot of good stuff in here. Um, so it's to strengthen family unity, have an economic impact, diplomatic relations. Actually, that was another point, is that they've been working with a lot of other countries like Colombia, Mexico, to try to slow down the migration to the United States. And this was a way to help a lot of Mexican nationals and others who are here in the United States who qualify. In fact, about 64% of those, they estimate, of this Biden Keeping Families Together program would be Mexican nationals. And my estimate would be a majority of them are in the Texas, California area. And so also resource allocation, reduce the burden of U.S. immigration enforcement. They talked about how much effort it takes consular officers, and if people, as can be done here in the U.S. at USCIS, as opposed to with the Department of State officers, then this can save a lot of resources. Um, so anyway, there's a lot of good reasons of why we announced that they announced this program, and they were started applications. So we are recording this, and this is coming out on August 27th. I had to look at my calendar for a second. I'm losing track of time. Today is August 27th, right? And so this program started a week ago, taking applications on August 19th. The Federal Register was announced on the 19th. It was unpublished and it went live on the 20th. And so those who weren't watching this every minute to minute, we didn't really have a lot of good details until the Friday before and the Monday of the applications. And that's where the FAQs and the unpublished rule, later the published rule, had a lot more detail. And that's really, we were going a little, I don't want to say blind, but it was very vague as to the details, especially about deportation orders, about crimes, and those types of things, as we went through those 60 days between the announcement and the applications. So we'll get to the likelihood of what the program later on. We're just laying the foundation here about the program. And then the other thing to note is the eligibility for stepchildren. So they had to be must be under 21, unmarried as of June 17th, 2024, be present in the U.S. without lawful admission or parole. And they just had to have been in the U.S. since June 17, 2024, till the time of filing. So that's correct. The stepchildren don't have to show the 10 years. And so that's really great for not having to show as much evidence, but they do need to show that qualifying relationship did happen before they turned 18. And so that they think there's about 50,000 stepchildren that would qualify for that. So the form is I-131F. The filing fee is $580. They are taking the applications only online with USCIS portal, and you upload the documents digitally. So like usually having them all organized and ready to go is what's important to be able to do that. So at this time, you can still apply for the Parole in Place program, even though there is a temporary restraining order that for 14 days, you still can apply. So we're going to walk through what that really means. So for preparing applications for spouses, we want to have the evidence of a valid legal marriage. So that marriage certificate, we also want to have the proof of their citizenship. So that's usually birth certificate or naturalization certificate, or maybe passport, US passport, and the documentation of continuous presence for the 10 years. So you're looking at June 17, 2014 until the time of filing. We're seeing probably a couple of documents per year. You could use your DACA receipts. You could use your tax and your income tax transcripts. You can use bills, birth certificates of your kids, those types of things. And so you want to organize your documents by those 10 years and have the proof. And I think it's good to have labeled them as much as possible properly what the document is. So showing for the stepchildren the evidence of relationship to that non-citizen parent, the documentation of that marriage, that it happened before the child turned 18, and that they've been here since June 17, 2024. The benefits of this program, I don't know if it needs to be said anymore, but it's a great program because first of all, you could, if approved, you'll be able to get the parole for 3 years. With that, you can apply for work authorization. With that, you can have a social security number. Once you have a social security in the US, that's your number for life. You also can use that to apply for a driver's license in states that usually require some type of a status. And also, most importantly, it is a pathway to legal permanent residency. And so then what that means is that if you had entered illegally one time, let's say, and you have a US citizen spouse, no other issues, and you're eligible for adjustment, then this parole would allow you to adjust status here in the country. And that's really what the intended purpose of this is, to reduce the backlog of the I-601A, to reunite families by reducing that backlog, as well as allow people to adjust. So recently we had there was the lawsuit that was filed of last week. And then we were working from the moment that we found out about it to basically the moment that the temporary restraining order happened on Monday afternoon. And basically we were submitting as many applications as we possibly could. Now, where are we? So it was 16 Republican-led states were sued the Biden administration, challenging the legality of the program. Those states are Texas, Idaho, Alabama, Arkansas, Florida, Georgia, Iowa, Kansas, and Louisiana, Missouri, North Dakota, Ohio, South Carolina, South Dakota, Tennessee, and Wyoming. So just a little note that if you're a US citizen and you're impacted by this because your spouse now cannot apply, or their future is uncertain, I would say make sure that you're registered to vote and think about this. So the gist of the lawsuit is that the authority is not unbounded. DHS may exercise discretion, but only on a case-by-case. So this is from prior lawsuits. I think they're generally saying that this is let's see, this is a challenge to unlawful agency action by DHS to grant hundreds of thousands of illegal aliens parole. Let's see, this is the established by Congress serve as powerful and disincentives for individuals to cross. Okay. It's claiming that it has unfettered discretion. Let's see, I'm just thinking like, so you don't want to hope 500,000 spouses of US citizens and all their stepchildren to be able to have a faster pathway to legal permanent residency, or to be able to obtain work authorization. I mean, many of them would already be eligible, but they were put on this invisible wall backtrack long process. taking, in cases about 7 or 8 years, if you count the I-130, the provisional waiver taking 4.5 years, the MVC, and then scheduling an appointment. And so anyway, they talk a lot about benefits and things like that. This will allow people, which is what you said in the rule, people will make more money, they'll have more mobility, they'll be able to move around, they probably won't qualify for government benefits, will have more funds in that mobility. And so there's lots of statistics in the rule as to why this is a really good program. So we are now 14 days is approximately about the September 9th or 10th. But what we do know is that you can submit the applications still. Let's walk through things. And before I do that, let's just go through one thing I forgot to mention. Once you submit the application, you get the receipt very quickly because it's USCIS online filing, which is great in that respect. The biometrics are being reused, done biometrics before, like I-601A folks, DACA folks, TPS people, done asylum. So if you've done your biometrics in the last few years, you probably get to reuse them. But because of this TRO that happened just yesterday, not letting people do biometrics that had been requested to do them, they're on hold. I've seen images about that. So but we will say people we've heard who applied on Monday of last week, the 19th, we heard of approvals as of like the 20th or 21st. So some people were able to get approved really quickly. So if you're planning to apply, you definitely need to make a USCIS account to My USCIS to be able to submit it, and it needs to be for the person who's the applicant, the beneficiary that's applying. So if you're the US citizen, it's not your account, it's for the person who's trying to get the parole. So there's a lot of great impact of benefits to this program, from allowing to reduce the backlog with I-601A, to not have people to travel, not to have to find other inadmissibilities with the go consular processing, not have to impact the consular processing officers, and not have to, people have to pay to travel, to be separated for the few weeks, to do all of those things, to be able to stay together, to not have to wait the 4.5 years for the waiver, for there to be more certainty for people who maybe aren't eligible for the provisional waiver to be able to at least have a work authorization, have parole for those few years, to really get people like out of the shadows and to get socials and get better job opportunities, not to be taken advantage of. There's so many really great benefits to this program. This also helps those who've been here a really long time, promoting the unity, advancing diplomatic relations, reducing the strain on U.S. government resources, and furthering national security. Okay, lots of good stuff. And we've had similar programs like military parole in place and some other ones. So those are some other options that happen. So let's go through basically a couple other questions about like the permanent bar matter. So from what we understand is if you have a deportation order, you left and then you came back in, the fine print looks as if you're not eligible, but some people are considering to apply anyway. For if you overstayed more than a year, you left, you came back in, it's a gray area. So I would still try if you want to, because if you could get that parole, then at least you get the parole status for 3 years, you can get the work authorization, you can get the driver's license, you get that social, it opens up doors. So, but this getting the parole, even if you're permanently barred, doesn't mean you're eligible for adjustment. And so that's one thing you need to think about. But but this could give you that chance to have that parole for a while, for 3 years. Now let's also talk about some other things, because of why not? If the parole is granted, and then what I would say, and you're eligible for adjustment, go to adjustment as soon as possible. Of course, every case is different, so have a consultation, please. This is just giving some general information. But what I would say is that if Trump were to win, I think he'd get rid of this program no matter what. So really, I think what would need to happen is if you get parole approved, you need to use it before and try to get whatever you can from the work authorization, the social, the driver's license, and what have you, because we don't know who's going to be president come January. So permanent bar implications, we talked about that. And then, okay, so let's talk about some alternatives. And I still haven't talked about what should you do now that there's this lawsuit. I'm going to get to that in just in a couple seconds. So again, if you have provisional waiver on the pathway, maybe you keep the provisional waiver pathway and you keep this parole as an option as well, especially if you've already filed or you're thinking about filing, because we don't know, maybe the program will continue. The provisional waiver is I-601A is still out there. If you have DACA, this was asked a couple of times. If you have DACA and you could get an advanced parole, it's taking about 3 months to get the advanced parole. Then you could apply for the advanced parole, try to travel, come back in and adjust if you're eligible. But just note that if you get the advanced parole for DACA, you're not eligible for this Biden Parole in Place program. And then let's see. The other thing is if you're eligible for something, really the Biden program was to reduce the I-601A. And then for those who had DACA and couldn't get advanced parole or didn't apply or didn't think they qualified, this was just another opportunity where they didn't have to travel. Okay. So it's just important to know, like, I would say at a minimum, have a consultation with an immigration attorney who understands this legal system as soon as possible. Because I was hearing a lot when we were talking through these TikTok lives and other webinars and programs and videos, people were, and even consults were saying they couldn't get through to their attorney, those types of things. This is a time to be able to talk to, get a consultation, have your case reviewed. We have this 14 days now. So either those who've already hired an attorney can either decide to keep going. Those who filed, they can continue to monitor and decide, this is either their plan A or this is their plan B. For those who didn't have a chance to get through to a attorney, get that consultation now, because things are calming a teeny bit. So the attorneys that did know and had experience, they were really slammed as this information came out. Now we can sort of take it in a little bit more. But be careful about notarios and people just say they're filling out this thing because whatever, like they don't understand the consequences of it all. So where we are right now is there's a 14-day pause, and they're still taking applications during this time. You could still submit your application. So there's different schools of thought. One is that you could submit it, 14 days, they might reopen it. They could continue the pause, this restraining or this, injunction. They could pause it, continued. But eventually the best case scenario would be at one point they open it, DHS wins the lawsuit, and USCIS can adjudicate as many pause as possible. The other point could be it stays paused for a while, then there's a window, and there could be an option where they say we're only going to adjudicate, which makes decisions on the people who had filed as of this date. Now, if that's the case, then you would want to have filed, because there might be some crazy cutoff somewhere that we don't know about, that anybody after this date can't even be considered. I guess the worst case scenario would be the program completely ends, DHS loses, and the 16 states get their way with the opposite of keeping families together. And then people lose their legal and their filing fees. Now, a lot of people that you have had in our clients that have filed, I'd say about 2/3 of our clients that filed this have had their biometrics already done, have another opportunity, like either they have DACA provisional waiver, and just this was an opportunity to move quicker. So for some people, they're not eligible for anything else. And so this was the best thing. Honestly, this is a really great program because it's quicker, it's faster, it's cheaper, you can move forward with life faster. And we really want to get people to legal permanent residency, or at least to get a social driver's license and work authorization for that mobility. And so right now, I would say you have a choice. You could have your consult, you can get your documents organized. You could either hire someone to prepare to file, or you could at least be holding by and waiting around to see what happens in 14 days and have your information ready. Like, for example, yesterday we got hired. We filed everybody who hired us as of yesterday that gave us what we needed. It wasn't because it was we tried, we were waiting for our clients to give us document. But now that there's another 14 days, this opportunity allows us for the clients to get organized and to be ready. And we've learned a lot in the last week of filing as many as we have. So the best case is to have the consult, get prepared, either hire and get ready so that you're in an attorney's list of cases to move forward and can move quickly. The other, if you're more paused, then you can sort of just have the consult review, collect your documents, and pay attention to see what happens. Or if you want to just completely wait, and wait even more to see what might happen. And so those are just some of the things to consider. Now it's unfortunate that we have families being put through all of this and I mean, tight resources to have to sort of go this yo-yo emotional prospect. I think it's really important to state that this is the time, this is a federal election year for all the US citizens that are listening and all those who are spouses of that don't have a status or who are somewhere in this limbo place, to make sure that you're registered to vote and to be aware of the issues and where the different candidates stand on immigration matters, because this is a constant thing. As a practicing attorney for 16 years, I am still dealing with this, and we haven't had comprehensive immigration reform, and we're dealing with these piecemeal little things can have a big impact, because if this were to have gone through, or once it was, fingers crossed, it goes all the way through, this can have a big impact for 500,000 plus families, because when we're talking families, we're talking about right. And spouses, but also the children. So in many questions, there's been, if I don't qualify, should I still apply? Well, I think that's a case by case matter that you should evaluate with your attorney, and you should have a consultation to see maybe you're almost there. Things that they've said in the requirements where they said that if you had any type of felony, you are not eligible. They also said if you have anything to do with domestic violence, you're not eligible, even if it was a misdemeanor. We also know that crimmigration is a funky. You might have admitted the elements of a crime. You think that, and so therefore it's not a conviction. It still could be one for immigration purposes. So I would say, for sure, at a very minimum, have a consultation. I would say that for everybody. But if you're being like, I don't know if I want to do that. Well, if you have a crime, if you have entered a couple of times, if you have a deportation order, if you ever were apprehended by immigration, I would definitely have a consultation. Because look, in matters like this, where you don't know what's going to happen, having had that consultation, having that power, that knowledge, that allows you to be able to jump when things happen last minute. I did consults this Saturday. People had done FOIAs, already had them in their hand. That was brilliant because we had those answers, as opposed to me having to say, oh, we're going to have to go wait 7 or 8 months to get those FOIA to find out that information. Okay. So, we are going to be providing a lot of information out there. I'm going to start answering some questions. I'll just say our number is 713-589-2085. You can call us, you can call someone else. Just make sure you check the reviews, make sure they have a good reputation. Some other cases, they have experience in immigration. And there's a lot of information being thrown at even the attorneys, right? We got the FAQ, frequently asked questions, last minute. We got the rule last minute, and we're trying really hard to get that all in. So you can reach us at contact@rubypowerslaw.com. You can reach us at, you can find us at rubypowerslaw.com and 589-2085. I'm going to go ahead and start answering some different questions that we have asked, and we want to just be a resource for you. If I were you, at the very minimum, have somebody who an immigration attorney that knows your case, reviews it. If you get a good vibe from have another one. This last week has been very crazy for immigration attorneys as we've been reviewing a lot of cases, reviewing our prior consults now that the information was provided. Now we have a little bit more breathing room. We can sort of think, but I think at the most point, have that consultation, have your documents. This is a really great opportunity if we can continue. What is the likelihood of this to continue? Well, there's been arguments about the executive action power, right? So DACA was from executive action power, and it was a lot of litigation started in 2017 under Trump, and fast forward so all the way up to Supreme Court and then down. I think in general the consensus was that they said it gave too much executive action, too much power to executive action in that. And so they decided to only allow renewals and not new. DAPA was shot down in February 2015. That was for the deferred action for parental rival. I think part of the argument, it's been a long time, 9 years, was that it gave too many people. Now the thing is that here they say in the rule that 500,000 is an estimate. It could be up to 750,000 spouses. It could be less. That was their average of the high and low scenario. But you know what? This is very, very rigid in a lot of aspects. You had to have been here 10 years. You had to have that spouse relationship. You had to no felony. You had, there's a lot of restrictions on this. I think it's very similar to the military parole in place in that respect, which has been a very successful program. And that's what they used in the rule to explain that this was all the benefits that came from that, and just the reduced anxiety from the separation of travel. And because when people do travel, there can be things consulates don't always understand cases. There's a lot more variables when that happens. So let's see. I'm gonna just answer questions about the parole program for right now, and then we can do some more later different topics. Should I apply for the I-131F regardless of the current 14-day stay order? Well, hopefully we've covered a lot of information about that and in today. Have that consultation, review your prospects. Do you have a backup plan? I think in general, if you qualify, I would apply because if that was me, because this looks like a really great opportunity that could reduce a lot of weight, a lot more uncertainty, a lot more cost. And it's great if you have another option, like if you could maybe try to do the DACA advanced parole, or if you do have the provisional waiver en route. But I think this can still be a great program. There isn't a lot of conversation about can I apply for a parole in place with an approved I-212 waiver? I think you need to have a consult for that, because is it 212 for a deportation order? What's the reason for the 212? It probably is. Is there a way to get the case reopened? Those are some things. Right, we answered that question. Let's see. If application already pending because before injunction, what do you think will happen? I think that you're in a better place than some others because you had submitted it, and they could have this cutoff some point later on that says only the people who applied up until this day will get adjudicated. We don't know, but right now it's a wait and see. So someone asked, I have DACA, should I apply for advanced parole or should I wait and see what happens with the parole in place? I think the biggest question on that is what's the likelihood of you getting advanced parole approved? If you have enough passport time, enough DACA time, and you can, that's something you've got to I would rather have a consult to answer that question, but you have to look to see how much DACA time you have, passport time, and could you get the advanced parole in maybe the next 3 months? Could you get family member, whatever the reason is, sick, health, work, your school, what's your reason for advanced parole? Because if you could do that, then you would, it might be a good idea to go ahead, but that means then you wouldn't be eligible for this program. But you also have to consider, we don't know who will be president come January. And I think if Trump has anything to do with it, he would probably try to get rid of everything we possibly have seen. And well, not that's being dramatic, but I mean, definitely he'd try to get rid of DACA, I think, and this parole program. So I think that how many months do we have left? So we have, it's basically September, October, November, December, January. We've got about 4 months. Have a consultation to evaluate that, but just think about the timing of everything. Okay. Well, I think we've covered a lot of material here, and we want this to be a place to sort of cover where we are from the last couple of months. And there was a question about, I renewed my DACA and I also applied for the parole in place. I got the appointment for the biometrics. Will I lose DACA? Well, the parole in place is not being adjudicated right now, and the DACAs can sometimes get approved really quickly. I think they had said somewhere that if a person was approved approved the parole in place, then the DACA might be denied. I believe that's somewhere in the FAQs. But right now, the parole in place is on hold. I think that you should still be fine, and we definitely have a consult if you haven't already had one to walk through the different scenarios. Because if you really felt at a inconvenience, you could maybe withdraw something if you needed to. Okay. Well, I think we've covered a lot of questions. I tried really hard to answer them about the parole program, and some of them are repeats of these questions. And I just really want to say thank you for all those who've been watching with us and sharing this information. We want to be a resource for you and all those out there in the community. There's a lot of information to come out, and this really has a big impact on many people's lives. And we just want to get what we know out there. And this could be changing. There could be something coming out and change this. But for the most part, this is a good summary of where we are from the last 2 months since the announcement of the program to this like heavily week. I think overall the message is if you filed it, just continue to wait. But maybe if you have another option, keep that in your sights as well. If you are thinking you've hired someone and you're preparing, I think I would still file. Just know that there could be an unfortunate halt at some point, but the program still exists. And and so I think that we covered a lot of material. Our number is 712-2085. Please feel free to share this with others. My name is Ruby Powers. I'm a board certified immigration attorney, Powers Law Group, and thank you for watching. And yes, they are canceling the biometrics appointments and for the time being because of the 14-day stay at this moment. So that is what we have seen. So thank you all for watching. You to be a resource for you, and we'll see you next time. Thank you.